A breast cancer victim diagnosed with stage 3B chooses electively to have a double mastectomy. Can the defense go after her for the fact that she electively chose to have a double mastectomy instead of just a single mastectomy? Would you like to learn the answer? Come join me as I share with you this remarkable information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now this woman is faced with a dire option. She's faced with a dire choice. She's been diagnosed with advanced stage 3B cancer, breast cancer. So now the patient is faced with a number of options. One of the options is to have a single mastectomy, to take off the breast that is totally affected with the breast cancer. The second option is to do a double mastectomy, where even though the breast is one breast that's unaffected, now you take it off as a preventative measure. And obviously there are additional choices as well. But the mere fact that she now chooses to have a double mastectomy, can the defense turn around to the jury at trial and use this as a defense and saying, listen, we didn't compel her to get a double mastectomy. True, she had breast cancer in one breast, but that doesn't mean she needs to take off the second breast. And if that's truly the defense that they're going to raise, now they're going to have to bring in medical experts to support the fact that she should only have had a single mastectomy as opposed to a double mastectomy. So let me ask you this question. Do you think that type of defense will resonate well with a jury, especially one that is sensitive to the fact that these types of breast cancers that we intend to show that the earlier the patient is diagnosed and treated, the better outcome they have? In all likelihood, I don't think the jury is going to truly appreciate that type of defense. However, that's not to say that the defense can't use it and try that defense as well as some other defenses, claiming maybe that the patient did not follow the doctor's instructions and also contributed to the delay in getting to a doctor to allow them to be able to diagnose her ongoing breast cancer. So why do I share this great information with you? I share it with you to give you an insight in some of the defenses that typically come up in these failure to diagnose breast cancer cases. I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.